Ashley Moen, Assistant Public Defender, appearing on behalf of Mr. Gray. State your name.
Thomas Gray.
I don't know if the Attorney General stated his appearance or not.
I'm sorry, Your Honor.
Did you state your appearance? I'm sorry.
I did not, Judge. I'm Special Assistant Attorney General Mitchell Wood for the people.
Thank you. All right. What are we doing on this case?
First, for these two matters, we are waiving. Mr. Gray is waiving his right to a exam.
Is that right, Mr. Gray?
Yes, sir.
You understand the preliminary examination is proceeding where the people would have to show by probable cause that the offense is alleged committed in it. So you understand you'll not have that hearing in either case and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over on a single count in each case.
We waive formal reading of the information and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrials in these matters will be set for
March 10th at 1:30 before Judge Hamoud.
March 10th, 2025, 1:30 before Judge Hamoud.
Judge, may I address bond?
You may.
First, for case ending in 5095, his bond is currently $13,429. I understand that the bond is typically 25% of the balance, but the Assistant Attorney General confirmed with me that his balance is $5,139. So his bond should be $1,284.
Well, that's because why?
I actually am not sure. I wasn't present at the arraignment, but it looks like there was an error because there are two cases and this was his old bond on the other case.
All right. So if his bond changes.
Well, I did want to address that, so that is adjusted, but also I was going to request a reduction in his bond because a couple things. He paid the 25% in 2023. He got a warrant for a failure to appear. At that time, he was homeless. Since then, he started working. He's being garnished for these cases. He's in truck driving school. He's also the sole caregiver of his father, who is very ill. We're requesting a personal bond, if necessary, a GPS tethered.
Well, hold it. You're asking me to do something the statute really doesn't permit me to do, right?
He did pay the 25% previously. Now he was arrested on this warrant. I mean, yeah, he's back here in custody because he had a warrant for the failure to appear. So I am asking for a reduction at this time because he's paid the 25% previously.
So you're saying in each case he posted the 20?
Yes, in 2023 he paid.
And then he didn't appear.
Yes, because he was
homeless. Has he been paying his child support currently? I mean, after posting, was he paying the child support?
He's indicating to me that he has.
Yes.
No, he has not, Judge, if I may.
Yes, sir.
No, he hasn't, Judge. He's had an intermittent wage assignment for small payments since he absconded back in July of 23. He's paid maybe a couple $100 in each case, all total over the last year and a half while he's absconded, Judge. But he did pay, and I don't know if your records reflect that. Back in May. I'm sorry, Judge. On June 1st of 23, you ordered that his bonds. He had a $3,600 or $3,160 bond in case number ending in 5077. He had a $780 bond in case number ending in 5095.
While Mr. Gray had paid some of his obligations, his payments have been intermittent. In particular, the records show he hasn't made consistent payments since his failure to appear in July 2023. Conclusion. The court will review the bond situation and the request for reduction, keeping in mind both Mr. Gray's current circumstances and the statutory limitations on bond adjustments. Legal proceeding summary. Mr. Gray's case involves multiple bond amounts across two...
You made a cash bond. You said pay it over. Never happened. It's not on the books. I don't know why, Judge, but I assume that your court still has these two bonds, 3160 and 780, but they were never paid over. So if, Judge, I know you have mechanisms to look into these things expeditiously. If you could, that would be great, because those bonds need to get paid over. But as far as what, go ahead. I'm sorry, Judge.
I have, okay. So that we're clear as to how this works, these go over wherever the cash bond is posted, it goes to Ann Arbor, to the 15th District Court. And I ordered, and I don't have the date, but I ordered that the bond in his case, because it did come up, that was to be applied to the FOC case. Okay, I have some information.
Okay.
Okay, so apparently somebody got something because finally, I guess they got paid over yesterday.
Oh, okay, that's good.
I mean, I also did one.
The checks were cut and it says what does it say?
Well, like, no, it just shows that there was a check cut and sent to circuit court.
Okay. So the note indicates the check was cut, sent to circuit court. I don't know where it is. We last time had to have them hand deliver in a case. So
Last time I submitted an order, and when I submitted the order, I was told that it should have automatically been done, but I am very happy to do the
it should
order.
have automatically been done,
Right.
because it's the magistrate's order
Right.
that once he paid it, it would be then sent to 15th and then sent to applied to the FOC
Exactly.
case.
Yeah.
All right. So so it's not showing anything paid, but my concern is he's also not paying what is his amount.
The Assistant Attorney General is saying that there are sporadic payments, but he is being garnished, and just so he knows, it is being split between about 4 cases. So
Judge,
if he's not meeting the cycling amount, likely that's why, but it is taking about half of his check every week.
It's not, Judge. I'm sorry. I have the record from the Michigan Child Support Enforcement System. I have a report dated February 24th. It shows that he did have in December, in October of 24, he had a wage assignment for a couple of weeks. And again, all total, I'm looking, Judge, he paid 71 on October 25th, another 53 on October 25th, 49 on October 25th. So these all, I don't know why they came in different amounts, but so one period in October, and then in December, he paid on December 6th. There was a wage assignment, but there's been nothing since then. So I don't know where he thinks, he does not have a current wage assignment. The last time anything came out was in December of 24. Judge, we know the purpose of these matters is to get him paying, but he hasn't been paying. I can tell you that.
That is something that we can definitely address in district court now that the case has been bound over.
However, you can address it in circuit court. You can address it before Judge Mood in terms of...
Right.
So I'm going to deny his request for a bond reduction or any change in the bond at this time. I want to leave the bond where it is. He's set for March 10th. You'll see Judge Mood. You guys can deal with it at that point and try to get this straightened out. We will, both for the people's sake and for the defendant's sake, we will make a call over 2/15 to try to make sure that the check hasn't been cut and is sitting in a pile to go over. We'll try to make sure that it goes over if it has gone over, so that there's a correct number when he gets there. That
Case number ending in 5095. The bond was $780. There was an issue raised regarding Mr. Gray's bond payments. The defense has requested another bond reduction despite his previous failure to appear in court. This request is based on claims of Mr. Gray's changed circumstances, including involvement in truck driving school, caregiving for his ill father, and efforts to pay child support. However, the court has reservations about the reliability
Perfect,
of
Judge.
these
And
claims.
one more matter
Given
regarding
Mr. Gray-
bond. I have no problem, Judge, if you reduce his current bonds, because he's been absconded for a year and a half. The bonds were set at the full amount of the original arrearage. I have no problem if you reset those bonds to 25% of his current arrearage. And then if he pays that in,
That is typically not my practice. I would leave that to Judge Hammoud.
All right.
Because it's not my practice, because the bonds only went up to the full amount because he failed to appear. So I'm going to leave those where he is. He needs to be here. And the only reason that he's here is that he hasn't done what the court's been ordering in the past. So I'm going to leave it where it is. Motion for bond reduction denied. We'll make sure that the checks get over and you can see Judge Hammoud. Thank you.
Thank you.
Thank you very much, Your Honor. Always a pleasure.
Yes, sir. Court.
Edward Drupas on behalf of Christopher Miller.
Yes, sir.
Christopher Miller, sir.
All right. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Right. The court's understanding of the plea agreement is that the defendant will be pleading no contest to the use of a controlled substance, that being cocaine, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor. That's correct, Your Honor.
All right. Has he signed an advice original?
Yes.
The basis for the no contest plea is,
Lack of memory, Your Honor.
may I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Christopher Gray Miller, Jr.
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of use of a controlled substance. Is that correct?
Yes, sir.
That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about it I have to make sure you understand. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Still wish to plead no contest?
Yes, sir.
And to that charge, how do you plead?
No contest? No contest?
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form today. Is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 23-4638. Any objection to the court having reviewed that report?
Objection, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
March 12th at 9 a.m.
March 12, 2025, 9 a.m. That's before me.
Oh.